I think we'll go ahead and get started. We call this one county by county, which is we really want to highlight this important part of North Carolina voting history and North Carolina's history in improving our situation on racial equality in particular. So we've called this the forgotten 20-year court battle for racial equity in North Carolina local government, particularly county government, but this also includes a lot of action at the city council level and other local bodies, particularly school boards. And we are, although by recording, very honored to have Professor Irving Joyner as our speaker. So we're going to be talking about really the story behind the fight for local government election reform in North Carolina. And as I mentioned, this is the first part of two parts, because this is such an important history and there's no way that we can cover it in one webinar. And we're very lucky to have been able to recruit Professor Joyner to give us some really important background and his perspectives on this. And then we'll take a deeper dive into some of these cases next time around, which will actually be in May, because we're going to do something on the day of action, which is April 29th, to try to get redistricting reform right here in North Carolina. So our aims are first to really examine this tremendous record of achievement in using the Voting Rights Act to reform discriminatory voting methods in the state. And as part of this, we want to highlight, I think it's a very timely message, to highlight the importance of individual and collective action in protecting voting rights, not only as with regard to what we see all too often as a pattern of racial discrimination in voting rights, but more generally. It's really up to us, the citizens, to defend our rights. We want to highlight also the role of organizations, particularly in this case, the role of the NAACP, which has played just a major role bringing a substantial number of these cases forward, and many of them resulting in important changes at the county and local level. And the way they've been able to do that is because of the Voting Rights Act. And the Voting Rights Act has two basic parts to it. It has what's called Section 2 and Sections 4 or 5, which are both very important. These have been used in North Carolina in particular to go up against at-large systems, where people run at large in the whole jurisdiction, the county or the city or the school board, rather than running by districts. And this is a way to racially gerrymander without actually having districts. And it has often been struck down, but there are still such systems in place in North Carolina. And this study also draws on the study by now Justice Anita Earls. She studied 54, she and a team of lawyers studied 54 Voting Rights Act cases that had been brought between the mid 80s and 2004, of which at least 17 involved the NAACP as a plaintiff. And this really shows the role that North Carolina's activists have played in fighting these discriminatory local structures, and as well as many other cases, of course, that have been brought in North Carolina to address other aspects of voting rights. And then, so we'll be discussing that more in our interview with Professor Joyner. So our guest, as I say, is going to be recorded, or has been recorded, and will be joining us as a recording. Has served on the faculty of the North Carolina Central University School of Law since 1982, and was associate dean between 84 and 92. He's authored 3 editions of the book Criminal Procedure in North Carolina. He has an extensive record of pro bono legal service in numerous civil rights cases, as well as criminal appeals cases, having served as legal counsel and chair of the redress committee of the North Carolina state branches of the NAACP for many years. And he's regularly engaged in litigation involving voting laws and redistricting plans in North Carolina, a struggle that, as we know, continues. He also served as vice chair of the 1898 Wilmington Race Riot Commission, which, of course, has been part of the effort to make that history better known, and to highlight the potential implications for preserving our democracy now, as well as the fact that this was the only successful coup in the United States in which an elected government, a biracial government, was overthrown essentially by an army. Professor Joyner was, it's an old habit as an academic, everyone's got to be doctor. Professor Joyner was named one of the NAACP's Humanitarians of the Year and for his work in defending Moral Monday protests in 2014, and also Lawyer of the Year by the George White Bar Association, which is the organization of African American lawyers in Durham County, as well as by the North Carolina Association of Black Lawyers. And he was also named, something that's very important for someone who is an academic as well as a scholar and a fighter for civil rights. He was named as the Professor of the Year by the students at the North Carolina Law School. So just to very quickly go over the VRA and other ways that we have for bringing voting rights cases. The Voting Rights Section 2 generally requires evidence from past elections, so it can be, it's a very important tool, as we'll see, but it can also be delayed in your ability to use it until you can accumulate such evidence. Secondly, the Voting Rights Act, like Sections 4 and 5, Section 4 identifies which counties or other jurisdictions are required to have preclearance by the Justice Department, and then the cases are brought under Section 5. And the problem is that that mechanism was struck down in 2013 in Shelby v. Holder. If Section 4 preclearance played an important role, not only through lawsuits, paving the way for lawsuits if the procedures agreed to were not actually followed, but it also played an important role in resolving these problems more rapidly through negotiation rather than having to go to court, which is both expensive and also tends to be drawn out. Recently, we've seen the state constitution's free elections clause, which I can quote in its totality, not being a huge feat of memory, that says that all elections shall be free. And that has been used most recently to require redrawing of the congressional and legislative districts in 2019. But it is an important protection that we and many states have, and is also important for voting rights. And then finally, you have state elections law, under which cases can be brought, obviously, through a variety of different avenues. This is a map of North Carolina showing the Section 2 cases, and in many cases more than one, has been brought in some of these counties. And the ones that have an N on them are cases where the NAACP, was a named plaintiff. And as you can see, these cases are all over the state, and especially you see a lot of cases in the East, but there are also a lot of cases brought really in, basically across the state, except for the far west, for reasons that I think are known to all of us. So we're now going to have a recorded presentation, as I mentioned, and please do put questions in the chat. And Professor Joyner has kindly agreed that he will answer questions. We'll provide them to him. We may also try in our more limited way to respond, as we can, but he will give us written responses, which we will distribute. And then the part 2 will be coming up in May. Maybe, Professor Joyner, you could begin by telling us a little bit about your work with the NAACP and other organizations to try to get fair elections and better representation here in North Carolina. I know it goes back decades, and that you've received a number of recognitions from the bar and so forth for this work, but tell us a little bit about it.
Well, I've always had an interest in voting rights law. It is something that started with me when I was a youngster, watching my grandparents who sought to register and vote here in North Carolina, being refused that opportunity due to the literacy test and their perceived inability to satisfy the subjective notion of the registrar in Lenoir County that they were capable of voting. I serve now as the chair of the Legal Redress Committee of the North Carolina NAACP, and I serve as its legal counsel, and I have been an attorney in a number of these voting rights cases over the years. So my interest, which started as a youngster, continues today, and places me in a position where I'm better able to challenge the kinds of things that happened with my grandparents when they attempted to register during the Jim Crow the old Jim Crow era. And we find in many instances the same kinds of things occurring today. And the NAACP has always been a champion of voting rights. So it was only natural that I would find myself associated with the North Carolina NAACP in continuing and engaging in that battle.
Yeah, the NAACP has played a really important role. I mean, they're the named plaintiff, as you know, of course, in many of these cases, but I'm sure that they played a role behind the scene in recruiting plaintiffs and organizing people in many more of the cases. And I hope that if it hasn't already been documented, that work will be, of the NAACP will be fully documented. I'm active in I'm on the Political Action Committee in our local chapter. I know Tyler's involved in the chapter in Greensboro as well. So, I mean, the NAACP has just played a really important role. The league was a co-plaintiff with them in the Dixon case as well as other cases over the years, and honored to have been a partner with them. We really think that maybe you could discuss their role in particular in the period that we're looking at, which is the 1980s and the 1990s. But as we know, the past is never past in the South.
Well, the work of the NAACP in this regard has been multifaceted, from organizing at the grassroots level on the ground, helping people to register in their local communities, conducting voter registration drives in those communities, engaging in voter education, as well as advocacy at the local and the state level to promote fairness in opportunities for racial minorities and disadvantaged populations to participate in the franchise. We found that registering is just one part of the process, and sometimes now that might be easier as a result of changes in the law, but registration doesn't always equate to participation. And so we promote this notion of getting everyone registered to vote, and then of getting everyone to participate, not only on election day, but also in the advocacy effort designed to maximize opportunities for people to vote, because many times that has been the bigger problem that we have encountered, that voting was restricted to one day in April or May, or one day in November from 9 until 7, and that many people who had to work full-time were not able, because of their employment and the inability to get off from work, to go out and vote. And then when they went to vote, there were inordinately long lines that they had to deal with. So a part of our effort has always been to improve the opportunities for people to actually cast their vote. And that's why we are strong supporters of the early voting process in North Carolina, and proud of the efforts that we engaged in to get that enacted as law in this state, and now that's followed in a number of other states as well.
Yeah, I think that makes a tremendous difference. Even though there have, of course, been efforts to restrict that, we're sort of waiting to see what happens this year. Other states, Georgia, I believe, just passed a horrendous voting restriction act that cuts back on early voting and even forbids handing out, bottles of water at people in line, which just seemed to be, maybe they forgot to put a requirement that people had to, like, not just get in line, but maybe crawl on their hands and knees and stand on their head while they're waiting. I mean, it's just, but I feel, on a more serious note that we're going to see some, I'm still waiting for us to see what's going to be proposed this year. And I'm sure that the NAACP will be standing up, as you have in the past, as will the league. Certainly, I mean, you don't have to tell us that voting rights are important, and that defending them is something that's part of the package. But I was really glad to hear you mention voter engagement, because I think that's key to getting higher turnout, but also just being sure that people are informed, and that process is really critical. I think we saw that as well in Georgia, on a more positive note. So, I mean, these cases, they really show, in fact, the importance of citizen engagement, because it wasn't, as you say, it wasn't just the lawyers. A lot of organizing, had to go into that, and the citizens themselves had to agree to step up and challenge, and challenge these cases, which can be time consuming, and they have to give depositions and so forth and so on. Could you comment on the role of the citizens who are not as well as the lawyers, of course, being citizens, but the voters and the local citizens who are involved in these cases?
Well, the citizenry is the key component of this right, and the notion of engaging, mobilizing, and educating that segment of our population is something that is at the heart of the work of the North Carolina NAACP. We have branches all over the state. So we have boots on the ground, and we have people who are directly impacted in so many different ways by the voting process and the effects or impacts of the failure to vote. We have members who seek to be elected to positions which we deem to be very important as well, because oftentimes an incentive to vote is based on who it is that you ought to vote for. So if you have attractive candidates that you have an interest in, then you are more willing to vote, and the task of encouraging people to vote is that much easier. A lot of people are past the point of voting for the lesser of two evils that used to exist in the state, and we tell them all the time that in just about every proposition, you will be a better legislator or a better city council member than those people who are presently there. Because obviously they've not supported the needs and aspirations that you have in your community. So you need to replace them so that government speaks to you, but also speaks your language. And the only way that it's going to speak your language is if you are in a position to have a voice. And if you don't have a voice in the process, not only just by casting a ballot, but also in developing policies, developing plans, and protecting the interests of those who would be deemed the least of these within those local communities. So we rely on citizen efforts as a part of our membership base. We are the largest membership-based organization in North Carolina, the largest membership-based organization in the United States. And we are proud of that fact. Within the NAACP, the North Carolina Conference of Branches is the second largest in the country, second only to New York, which is a huge state. So we are proud of the citizen involvement that we have been able to create, and that the citizen involvement that we've been able to mobilize and help to show up at the polling place, and as they say, show off within the political process.
Yeah, it's so important. And the local offices also play an important role in getting people involved and getting them engaged so that they can run for higher office. I mean, when people run for these county commission seats and municipal elections and other local offices, school board and so forth, that really prepares them to go on and run for some of them, not all of them, of course, but some of them to go on and run for higher office. And when those are blocked because they structural barriers to getting elected, that makes it much more difficult to develop a real bench of qualified candidates. So I mean, I think that and of course the educational activities which the league engages in and of course NAACP engages in are very important in encouraging people to take that step and really put themselves forward, as candidates or as volunteers working in campaigns for that matter. We saw that many of the lawsuits, were in counties that were covered. There were 40 counties in North Carolina, as I'm sure you know, that were covered under sections 4 and sections 5, which unfortunately, were struck down in Shelby v. Holder. One of the few redistricting cases that wasn't a North Carolina case, I swear. And so how would you say that how hard has it been to get change in these systems using 4 and 5 and or how was that battle?
Right. Well, let me just start off in response to that question by referencing back to March 7th of 1965. When voters in Selma, Alabama, were attempting to cross the Edmund Pettus Bridge as the first leg of a voting rights demonstration headed toward Montgomery. And Bloody Sunday, where these marchers were viciously beaten by law enforcement officers and other supporters of the police at that time. John Lewis being severely beaten in the head, along with hundreds of other people who were attempting to cross that bridge. That was an impetus for the passage of the 1965 Voting Rights Act. And it is certainly ironic that the place that the Voting Rights Act began became the situs of where Section 5 and Section 4 were restricted by the court. We're talking about the same Shelby County, Alabama, that had more voting rights challenges directed against it during the life of the Voting Rights Act than any locale in the country. And it is certainly ironic again that that Shelby versus Holder would spell the demise of the prerequisite pre-clearance requirement of Section 4 and Section 5. Section 4 identified the specific jurisdictions in the country that had a history of efforts to prevent African Americans from registering to vote. And so Section 4 was the identifier that placed in the law those locales that had been active in resisting efforts by African Americans to be able to register and vote. And that effort included a number of states and 40 counties in North Carolina. 40 counties in North Carolina because that's where the bulk of the African American population lived in 1965. You had at that point roughly 70% of African Americans in North Carolina lived in the eastern part of the state, and those were the 40 counties covered under the Voting Rights Act. And the fact that you had a pre-clearance procedure under Section 5 that required that any effort designed to in any way impact the voting process had to be pre-cleared by the Justice Department or a 3-judge panel in the District of Columbia Federal Court, that saved a lot of the repressive acts that were being attempted during that time. And its value was not only in what the Department of Justice was able to do, but was in the fact that ordinary citizens could lodge complaints. You didn't need a lawyer. You didn't need to have a litigation budget in order to do so. You could write a letter. You could send a telegram. You could, at every level, file a complaint about what was going on in Buncombe County or Lenoir County or Pitt County, or what was going on in local cities that impacted the ability of people to vote, and that you had a remedy available to you because there would be an investigation. And if there was support for the probability that the enactment would have a negative impact on African Americans or people of color or part of the protected classes identified under the Voting Rights Act, that the Justice Department could prevent those enactments from becoming law and make it illegal to implement those. And so it was very important. And people did respond. In North Carolina, people responded. And every time there was an effort that was deemed to impact negatively the rights to vote, the Justice Department was contacted and they responded. They responded. And so it put citizens in a position of power that they've never had before in this country in attacking suppression efforts by people in the local community. When that was declared unconstitutional by a misinformed U.S. Supreme Court, that took away a mighty tool and also added in the necessity of having a bank of lawyers available who could go into court to challenge enactments under Section 2, which is always an effort that occurs after the fact. Section 5 dealt before the fact. After the fact, when people have been harmed by their inability to vote, because if you can't vote in this election, no remedy provided by the court is going to allow you to go back and cast that vote. And Section 5 provided that remedy. Section 2 comes after the fact, after there has been illegal elections and people elected illegally and efforts illegally to prevent people from voting. You can't repair that. You can't repair that. And the cost of litigation in Section 2 cases can run anywhere from $10 to $15 million. Because of the experts and the evidence that you need to gather and present in court. And you know that in every one of those efforts, you are starting at the local level and you're going to end up at the U.S. Supreme Court, a time-consuming process. So typically 4 or 5 years later, you have a final resolution of the claim under Section 2. Section 5 didn't pose that problem because immediately upon there being credible evidence that the enactment would have a negative impact, you could stop it before it was implemented. And that was a godsend for those of us who were engaged in voting rights protection work across the country. Now we are pushing to repair what the Supreme Court did. And that is a monumental battle, one that is fraught with all kinds of difficulties and all kinds of opposition, and that opposition is growing daily. You have an entrenched U.S. Senate 50% right now that's opposed to anything that would give to people the right to vote and enlarge the opportunities for them to vote. So we dearly miss Section 5, and its impact is going to be with us for a while until we get more citizens to come out in these local communities and replace some of those people who are in opposition on the Senate side and on the House side within in Congress and in the state legislatures as well, because state legislatures can do more, much more than they have done in the past to expand opportunities for people to vote. And I know I've taken a lot of time going through that, but that was laid on my heart, and I hope you will forgive me for the elongated response.
Oh, no, not at all. I think it's really important for people to understand why the loss of Section 4 and Section 5 is such a problem, despite the fact that you still have two. But as you say, not only Section 4 and Section 5 are so much faster, you don't have to wait to accumulate evidence that in fact it has a discriminatory effect, in another election, and then it really drags on, and the cost and so forth, and the fact that, as you say, those elections can never be run again. So that impact is going to be lasting, even if they specific things are overturned. But we can be hopeful that they will restore the Voting Rights Act and come up with a test that will survive court challenges, because whatever test they come up with, we know it will immediately face a challenge from somebody somewhere, and that and hopefully that it would be able to continue to be used during that period. But I guess that depends on what the court says, whether there's a stay or whatever. But I'm not a lawyer, so I'm just play one on TV here. But as I understand it, another real benefit of 4 and 5 was that you had a very informal negotiation process going on in the background between the local government, state government authorities, whoever was affected, and Justice Department saying, well, how about this? Well, let's try that, and it had a much more flexible process to come up with something that was satisfactory, at least, if not ideal, to both sides, so that you could go ahead and proceed. And then that really, that's gone that's not there in Section 2, that ability to just proceed informally and find a solution.
Yeah, it was a hatchet over the head of legislators that we could use, and the threat of using that oftentimes, as you mentioned, brought about clearer thinking by those who would otherwise be inclined to enact some suppressive type legislature, and you could work it out so you didn't get to that point. But even when you got to that point, there was still room for negotiations and the ability to find a just resolution. Section 5 brought about some just resolutions. In the case of North Carolina, for instance, we utilized Section 5 to result in the first time election of members of our race to city and town council, to county commissioners. The history of exclusion in this state runs deep. It is a persistent history that shows an ongoing effort from generation to generation, from decade to decade, to keep African Americans from utilizing their power to register and vote. And we go back to 1898 and the Wilmington Massacre that occurred and resulted in the end of the first Reconstruction in North Carolina. And from 1898 until 1990, no African American was elected to Congress from this state. From 1898 to 1968, no African American was elected to the North Carolina General Assembly. And then after that, it took another 10 years before we had more than 4 members elected to the North Carolina General Assembly at the same time. So it's a history that is very, shows persistent, ongoing efforts to prevent African Americans from voting. Even in our success, that opposition continues as late as 2010, when the Republican takeover occurred. The first thing that they sought to do was to redistrict the state to give to the Republican parties the ability to create a veto-proof legislature. And then as soon as Shelby versus Holder was decided by the court, they enacted what we call the Monster Suppression Act. And to its credit, I don't like to beat the drum too hard, but the NAACP was right on the battleground and began to fight successfully against all of those efforts. And along with our partners that existed around the state, we've been able to temper some of the more egregious things that the legislature has come up with, but they continue. And you mentioned Georgia earlier with their efforts to minimize voting opportunities in Georgia. We fought that battle beginning in 2013. We won. And it's back again in Georgia, where North Carolina has been a kind of model for other states to follow. But we face it again here in North Carolina, because a victory over this suppression does not end it, because they just come back and retool, reformulate what it is that they're doing and try it again. And we have to continue to be vigilant and to fight back against those efforts. But we're pleased that I think North Carolina is on a high level of alert. We have strong partners, like the League of Women Voters, for instance, that's actively monitoring and fighting these efforts in the state. And we're proud of the fact that we're not fighting this battle alone, that other people are aware of what's going on, and they are willing to fight. And they have proven themselves to be warriors in the struggle to protect voting rights.
Well, I did just want to say, just listening about the Section 5 and Section 4, being taken out, and the monster 2013 bill that passed, and that conversation. I think it's important that we should, let people know, they don't know, that the Fourth Circuit said that bill targeted African Americans with almost surgical precision. That came from the court ruling right after those sections were struck down by the Supreme Court. And so I was just thinking about that as we were talking about it. But one of the things I'm really concerned about is something like that passing again. In response to, we saw what happened in Georgia and what's going on in other states, and how we can be prepared here to counteract that, and hopefully ensure it doesn't happen, but what we can do if it does happen.
Yeah, well, we can count on the fact that there will be efforts to cut back on the opportunities to vote. Those efforts have already started. And one of the things that is high on our list with litigation is to help our judges better understand the reach of the state constitution and how the state constitution ought to be interpreted. And if we are successful at that, then we can counter some of the things that the legislators are attempting to do. You know, the focus here is power and a power grab and who controls the power. Under our state constitution, the power is in the hands of the people. The first provision of the Constitution says that all power in the state belongs to the people. In the General Assembly, they are of the opinion that all power in the state belongs to state legislators. But there is nothing in the Constitution that gives them that power. They are our representatives. We are not their representatives. And so it behooves us to constantly engage in efforts to help them to better understand their role and their position in the process, such that people are taking back the power to form and control and manage our government. It's not their government. And so I think people lose track of that as they seek to enmesh power around them that they can exercise over the population. And so our effort has to be in countering that notion and defining clearly what do we mean by the democracy, you know, and what's the reach and the scope of this democracy. And that's our role. That's our role. And the state constitution speaks boldly to that fact. And we have to be very vocal in articulating that fact by making reference to the specific provision of the Constitution as we help them to understand what it is that they need to be doing. And if they can't, then they ought to be removed. They ought to be voted out of their position, because we have the power to terminate their employment as our representatives. And that is what they are, even though they don't think so. And so it's our job to be vocal advocates for what the founders of the North Carolina Constitution intended when they enacted the specific provision in 1868 as to what the North Carolina Constitution would become.
Right. And I think that is so right about, it is about power. It's about legislators trying to maintain their power. And that's where a lot of these bills come from.
I mean, in these cases, but we're looking at cases that were discussed in particular in really a landmark study by now Justice Anita Earls, which she wrapped up just before she founded the Southern Coalition for Social Justice, which of course has also been, and continues to be involved in bringing these suits as well. The most recent one I think was 2017 in Jones County, where an at-large system was overthrown and resulted in the election of the first two Black members of the commission, I think possibly ever, or certainly since Reconstruction. That this is not it's of historical interest to understand how we got to where we are, or in some cases didn't get to where we wanted to be. But these cases are they're ongoing. There was just an article today, and I don't know whether you had a chance to see it as we're recording this, in the North Carolina Policy Watch about Alamance County, which is another at-large system that continues in place, and where there was an unsuccessful effort in that case to try to overturn that. But hopefully, those efforts are continuing to try to undo these at-large systems. And we'll be talking about why these are bad and the impact that they have, particularly with regard to racial justice. Another part of this is that many of these resulted in consent decrees that were put in place as part of the suit. And not being a lawyer, I mean, I know what a consent decree is, and that's about it. But as I understand it, many of these remain in place and will affect the redrawing this year, as they have in the past, presumably. Could you comment on that?
Yeah, there are a number of consent decrees back from days of old that continue in place. Some of them time limited, others or not. But every 10 years, you run into a redistricting process at all of these levels, which provides an opportunity to redraw and redraft what the legislative lines look like at the town level, at the city level, at the county level, and certainly at the state levels, where you redistrict based on population changes, and they are always population changes here in North Carolina. The population has grown tremendously since 1970 here in the state, and it continues to grow, bringing in some good people and bringing in some bad people. It creates an opportunity now for us to add another congressional representative. Just 20 years ago, we added the 13th congressional representative here in the state, and now in a short period of time, for those of us who are older, those of us who are younger, it's a long time ago that now we're at a point that we may add another congressional representative, and that's going to cause a changing in the lines. We also have shifting populations. At one point, you had robust communities in the eastern part of the state. Now, many of the residents from those areas have moved into the urban areas, into the cities, Raleigh and Durham, Greensboro and Charlotte, because that's where all of the action is in their minds. But it has caused population shifts. And so we have to look at that so that we can equalize the political power as it's now vested within the state. And it's a painstaking effort that we are engaged in to look at every city enactment, every town enactment, every county enactment, and all those things that the legislature is doing with respect to the House of Representatives in the state Senate, and then the congressional representation. Repeatedly over the last 20 years, we have had litigation galore at all of those areas. And in most of those cases, there has had to be redrawing of the lines that exist, and changing of the opportunities for people to run, to be elected to these positions. My point is that it's an awesome responsibility to stay in touch with everything that's going on in light of the changes that we've had, and we've been further challenged by COVID-19, which has immobilized us to a large extent, but the work has to be done. The challenges have to be raised, and if we don't do it, no one else will, and if we don't do it now, it won't occur soon enough. So we are geared up now to challenge both in the legislative chambers, at the county level and at city level. We're ready to challenge, and that was one of the reasons that we are so thankful for all the foot soldiers that we have as a part of the North Carolina NAACP. We are the only organization with foot soldiers all over the state that's monitoring things that's going on, and the laborers are mighty, and the battles are many, and but we have a smaller contingent of lawyers that are available to go out and work with those populations. But we're doing everything that we can to move forward.
Well, I think that it's so important for people to get involved in this, and part of the impetus to our county project, county redistricting project, was to really encourage people to get involved at the local level and in the county and municipal, for that matter, redrawings where they have districts, because we think that it's important. Those jurisdictions have a huge impact on school funding, on all kinds of local services, the jails, the elections, for that matter. The commissions fund the elections, so we think it's maybe easier for people to kind of, they may be hesitant to try to get involved in the statewide redistricting, but the county commission, I mean, they know their neighborhoods, they know what's important to keep together, and there are new tools to do that, such as Representable and Districtor, which are just point and click. They don't require any kind of programming knowledge or anything to define what is your community where people share interests that you think should be kept together, and be able to to participate in public hearings. We do hope that despite the truly strange schedule we're going to have this year, that this will not become an excuse to limit public input to these processes up front, because, as you say, if people don't get involved, then it's more likely that there's going to have to be involvement on the back end for court cases, which I think, in principle, we'd all like to avoid, but it is more important to ensure that people have voting rights, no matter what it takes, and it's relative to the cost of people losing voting rights. These court cases are a small cost to bear, because that cost is, as you mentioned, is irreparable, and it's also damaging our democracy, which is, if we don't have that, what do we have? So do you think that we will be able to get maybe a better process and stricter criteria, and get a redrawing that will perhaps not result in as many court cases? Well, how do you see the chances for that?
Well, you always hope. The reality in North Carolina, though, would suggest that it is going to be a struggle again. We're looking to get people engaged in the effort while these plans are on the drawing board, to begin to challenge them as they are being prepared, and the creation of alternative plans that will work for a particular city or town or the county, and then indeed the state legislature. Because if we can promote needed change in the plans, then that minimizes the necessity of going to court to get involved after the fact. But we also want to create a record in every locale, showing that those persons who are in power and who are making these decisions had available to them the knowledge that what they were doing would have a detrimental impact based on race, and that they were aware of the probable impact that it would have on the community, and with that knowledge, they went ahead and did something that was adverse to the community. So if we're successful, then we won't have that problem. If we're not successful in terms of changing the drafting plans that they have, then we have a better record that we can take into court to challenge what occurred at both the state court level and at the federal level, if we decide to do that. Because increasingly, we are looking at the power of the state constitution and the requirement that the state constitution be interpreted in a manner that maximizes protection for our citizens here in this state. In the past, the state constitution has not been widely used to promote voting rights protections. And now we think that there is a legal basis for the state constitution to be interpreted in a manner that it is going to guarantee and give better guarantees than you find under the Voting Rights Act and under the 15th Amendment to the Constitution. So all hands are on deck, and all avenues of protections available to be used, and we want to utilize all of that, even if we can't get Section 4 and Section 5 revised as a part of the Voting Rights Act, that we create a body of law within North Carolina that has the effect of doing the same thing that Section 4 and Section 5 would have provided to us and would continue to provide to us at the federal level.
Yeah, I mean, we saw, for example, in the last, most recent redistricting, as you know, we're under the state constitution, the fair elections, the free elections clause, which it's admirable in its brevity. It says all elections shall be free.
Yes, yes.
That's all it says, but it's a mouthful. Though.
Big statement, big statement.
Very important, and the state courts, at least from what I can see, are also a lot faster than the federal court.
Yes.
The federal court may bring justice, but justice delayed is justice denied. The state courts are just a lot faster, and we can, I think we will see, more action in the state courts. Although it does depend a lot on, who those judges are who are named to the 3-judge panels, how, because there are different perspectives, even though the judges are required to be impartial, they still do, of course, bring their own judgment and are expected to do that to the decision. So we hope that we will continue to develop that. I think is an important strategy, getting people involved, and it's easier, I think, for people to follow the state court as well. It's closer. They kind of know the judges, and
Yeah.
it's really an important mechanism, as you say. And we've just seen that.
Yeah.
I thought it would maybe be good if we could go into a little bit more on how at-large systems disadvantage minority groups, because many of these county, many of the lawsuits were regarding at-large district, at-large systems which don't even have districts. So why would a districted system work better?
Well, let me kind of, again, this might get a little long. Let me kind of just waffle back to 1947. And this was before a lot of people were born. But in 1947, for the first time after 1898, an African American was elected to the city council in Winston-Salem. And in that race, Reverend Kenneth Williams was engaged in a battle against, one-on-one, against a white candidate. And for the first time in modern history, he won. It was the first time in the history of the South since 1898 that an African American had competed heads up against a white candidate and won. Immediately after that, that was a district-wide campaign. Immediately after that, the state legislature went into session and then created this multi-member district. These multi-member districts would be created at the town and city level, at the county level, and at the legislative, state legislative levels. And wherever there were large concentrations of African Americans, those populations were subsumed under this larger apparatus, which always allowed the white community to outvote the will of African Americans in those locations. And the reasons that, for instance, in Winston-Salem, African Americans were in that one particular district was because of the discrimination. housing discrimination that existed during those times that caused African Americans to be located in certain political districts, kind of like it is today. That we are bunched together in so-called African American communities. And so the effort with multi-member districts was to surround those districts with white voters who would always outvote the African Americans and to deny to African Americans the voters of their choice. And that is a battle that has continued since 1947. It is still in play today. Despite the Thornburg versus Jingles lawsuit that we were engaged in, where we challenged the multi-member districts at the legislative level successfully and created single-member districts in all over the state of North Carolina, which caused the number of African Americans elected in the North Carolina General Assembly to increase from 4 to 16 in 1 year. And it was, 1990 that you had as many as 19 African Americans in the North Carolina General Assembly. Today, it's double that. But it resulted from the breakdown of these multi-member districts because they have meaning. They particularly have meaning where you have polarized racial voting, where whites, as a rule, will not vote for an African-American candidate. In 1947, it was probably the law of the land. In 2020 or 2021, it's probably the semi-law of the land. But today we have a situation where increasingly whites are beginning to recognize the value provided by African American legislators, and they are voting that way. So you don't have the same level of racially polarized voting today as you had back in 1947. But this racially polarized voting is still present. When you go into the rural areas of our state, you will see it. When you go into the western part of our state, you will see it. And many of them end up voting for one party over another. And it is a battle, and the nature of these multi-member districts has caused an underrepresentation and the denial of people of color their ability to elect people of their choice. And that's what we're looking for, is a fair shake. And district election has always been better for that because they provide for a more equitable sharing of the power that exists to allow people to exercise their choice. And in this choice, it's not that African Americans will always elect a African American. It is that they will elect a person of their choice, no matter what the race is, because you're looking for someone who is going to best promote the interests and rights of people who are in the community. Because all of these communities are whole. We live in it together. So we have to be able to prosper together and share both the burdens and the benefits of our democracy. And democracy calls for a robust participation. And with this robust participation, a lot of the racial animus that existed can be minimized. It is where we are working together toward common goals that we are able to overcome misconceptions and stereotypes about others when we begin to interact with them on an equal level, given better respect across racial lines. So it's very important for any number of reasons that we promote this notion of district-wide elections.
Yeah, when I was involved in updating our redistricting policy, I was looking at the legislative level and congressional and so forth. But in our policy, there was a statement that the league, that apparently had been there for many years, that the league favors single member districts for local elections. And I left it there, not frankly thinking much about it, but I have come to learn, studying the county redistricting and other local redistricting, how important it is to have single member districts and not to have at large. And these court cases, I mean, there are more than, almost 60 court cases that were brought, many by the NAACP as well as by others, to challenge these at-large districts, and generally speaking, to be able to overturn them and introduce true districts of single-member districts. But it is very important for good representation, to have that, and it's really a record of achievement that can be pointed to by the NAACP and local citizens and their lawyers and everyone else, that got that done to really move our democracy forward by permitting the voice of the people, in their neighborhood, in their part of the county or the state or the city, to be able to elect the representative of their choice, and not for that not to be subsumed in a different view by a larger chunk of the population. So it is really critical, and it's I think an achievement overall that we're very glad to be able to shine a light on. How much work was done, and the tremendous effort of the NAACP and the lawyers and citizens and everyone, that really shows that you can get it done. Also, that you can get reform. How even if it's hard, and it takes, in some cases, as in this case, it's taken decades to get this done. And there are still a few holdouts out there, but it can be done if people keep at it. And certainly your personal involvement in that, Professor Joyner, is really something that we want to celebrate as well, and to thank you. I'm sure not that your time of doing this is probably not done by any means, but to thank you for all of the work that you have done and leadership that you have shown to bring these changes about. And so important for all North Carolinians that we live in a state that is fair to our citizens and gives an opportunity for everyone.
Okay, well, thank you for this opportunity to discuss it. Look forward to discussing it further, and you all do great work, and we're in this struggle together.
Thank you very much.
Thank you very much.